is unfortunate. It was a late night party. There were a lot of intoxicated people there. Some of the people that got, the individual that got injured, we believe precipitated and instigated and caused and got into a physical altercation with some people there. However, you have the right to defend yourself. So it is what it is, but this is a long story and the truth will out.
So, going in today, what were you guys hoping maybe the next step in this?
Okay, we were going in hoping that there wouldn't be a gang assault. We were hoping that the charges would accurately reflect what we believe transpired at that evening. And there is a gang assault too, and we don't feel that is reflective of what actually transpired that evening. And there's a lot of witnesses to that.
Gang assault is very rare charge, you can see.
It is very rare, and it's usually when there's a gang, and it's usually when a gang does something. We don't have that in this case.
So obviously the next thing is in October, it's virtually. Do you think that's going to be harder? I know that's...
The judge has indicated that the virtual does take longer, and with technological differences, and the New York State just changed who we're using as a software provider, it's not easy. It will get accomplished, and I'm confident that we will get all the discovery in due time.
And obviously, you've been saying it's been going on for a while, and all of the defendants seem to be from the area, have very good jobs,
and well known and connected to the community, invested in the community, and have deep roots in the community.
Well, frankly, it's disturbing, the indictment that was presented here today against Kelly. There's allegations revolving a gang assault, which factually as well as legally doesn't fit. I'm not sure if anyone knows much about this, but at the time my client was 7 months pregnant, very pregnant. And the prosecution's theory on this is that the complainant in this case, who was a guest at a party, frankly got into 2 or 3 separate fights over the duration of 45 minutes. And what the prosecution here is trying to do is trying to say that because this individual who was combative fought with somebody minute 1 and then 45 minutes later got into another fight, they're now trying to lump this together as to be a gang assault. In order to be a gang assault, there has to be a shared mens rea, essentially a shared intent. One fight may not even known about the earlier fight. There was some press-related information that I read that this individual had to be intubated because how bad his injuries are. When in actuality, what had occurred that this individual was so drunk and antagonistic with the medical professionals that he attempted to fight them in the ambulance and then was intubated based upon how combative and aggressive he was. So that's the type of case we're dealing with here. Those are the facts that, frankly, the media is not aware of, and unfortunately, because of the public outcry based upon misinformation, this indictment has been brought down. I don't think legally there is grounds to charge my client, a well-respected member of this community, as well as the Sheriff's Department, with the level of charges that they've been brought here, and she will vigorously defend this matter. I suspect it may not hold up to motion practice. So we will see. So thank you for your time.
As I indicated in court, my client, Mr. Haig, is in a very unique position here. He didn't know this individual before.
Thank you.
This individual was intoxicated, he was belligerent, he was abusive. My client responded as any being would, which is to defend himself in the face of attack. It's very straightforward, it's very simple. We shouldn't be here, we are. He looks forward to defending himself in court to explain the circumstances of this. We also have an intoxicated person who's seeking to profit off of this financially.
How's that?
He's made clear that he is looking for money and lots of money, and I think that aspect of this case will also be very important to understand his motives.
The gang assault is a very rare charge.
It is, yeah.
What do you think of that?
Well, it's obviously a very serious charge. we're going to address whether we think it's appropriate in this case. In addition to the factual issues in this case, which I just mentioned, I think there's legal issues also. We're glad to be here. It's been out there for 3 months, a lot of rumor, a lot of innuendo, and unfortunately, what is on the internet is not only true and accurate, and we don't get a chance to address the truth of this case until we get to court. And from that point of view, my client, who believes in the system, as difficult as it is to be here, is glad that he has this opportunity.
Seats have been designated with round dots for this purpose. As counsel or parties wish to have a private conversation, you will be allowed to leave the courtroom and speak privately in an area.
Brian Pate.
Thank you. Before we get into
with respect to the third, it says Harold Handy indictment. I don't think that in any way, shape, or form is sufficient either with respect to an accurate.
Obviously, this is arraignment, so that factor does not weigh in. However, in order to be heard by the court, the application must be of sufficient nature, and those before this court do not.
And confirm that I've been in receipt of what document entitled Bill of Particulars, identifying this indictment 20-027.
Waiver reading and enter not guilty to all the counts of the indictment in which my client is named.
And the other sections below that Mr. Ford outlined. I too would waive a reading of indictment, enter a plea of not guilty on behalf of Mr. Pate, and reserve his rights.
Thank you. I will usually.
So that was 10:23.
Yeah, you'll get it.
Well, I just wanted, if I
10:23 at 2:30 p.m. And again, that will be. By the way, for those of you who don't know,
Dave, do you want to?
anytime within the 45 days, sir.
Thank you.
At this juncture, two things. One is, as the court is well aware, it issued a criminal summons with respect to family court proceedings that Mr. Rosenstrach has been involved in. He has appeared each and every time he's been required to.
In the area, at her residence here in the county. She is a recent mother, and she will abide by all instructions to show up to court. She here deny interactions with my client. She will be here as directed and remain directed at all times.
Thank you, Mr. Howard.
That bail needs to be set to produce his appearance. We appeared voluntarily.
As to the least restrictive means, which would simply be released upon his own recognizance.
And that I will direct that by 3 o'clock this afternoon, all 4 defendants
that have sought to possibly involve my client in confrontations or other situations in the community. There's been no contact between.
Since July 4th or 5th, there's been, to my knowledge, no allegation.
Mr. Roberts said this case and the facts are that an intoxicant.
There's a letter for you as well.
Judge, can I get it from my client, please?
No, Mr. Gaylord can come up and get